Hi, this is Steve Hubbard again with AMVSR LLC. In a previous video, you saw how we took the video coming from the courtroom. This is archived video, not transcribed, but we took the video portion of the screen on our computer and then placed the transcript window side by side so that you could see the real time. Now, if the court were to make an arrangement with us to say, Mr. Hubbard, if we could stream to you just the audio, and maybe the video as well, so you know who's speaking, or we have a digital court monitor who is putting down on paper or on electronic paper the change of speakers, so you know at 0 hours, minutes, and seconds who is talking as far as interruptions like objections or addressing the court between and amongst counsel. The Q&A would obviously speak for itself. However, if we were to stream to you live the audio, could you do the following? And that's exactly what you're going to see right now. All right, let's go and get ready.
This is my last hearing for the day. A hearing for later on today was continued, so I won't put time restrictions on you. We'll have formal appearances at this time. On behalf of plaintiffs,
Sarah Siskind, Your Honor, Minor Barnhill and Galland from Madison, Wisconsin.
and on behalf of Kraft. Okay,
Your Honor, I'm here with Ron May as well.
I didn't hear.
I'm here with Ron May as well for
Yes,
plaintiffs.
thank you. I will caution you at the start. This isn't a suggestion I need to have a different judge in the case, but when I was in college, I worked at an assembly facility, a bakery, where we baked mostly high volume production of bread and rolls. Ever heard of Old Home? That was where I worked all those years in Sioux City. And I know a lot about donning and doffing and walking from place to place. Naturally, at the bakery, I had to be pristine, clean.
I'm going to pause it there because the streaming audio that's coming to us could be in a buffer, and we can control the buffer output. Meanwhile, the buffer is still continuing to take the audio, but if and when there will be, and there will be, fast questions and fast answers, we could have at our end a digital court monitor controlling the flow coming into the computer. Eventually, when microprocessor chips are not any longer quad core, but double that, and higher real-time clock speeds, and more memory in the PC, speed will be rendered totally irrelevant. But if you're streaming from this courtroom in Iowa, and we're capturing the voices like you're seeing now in real time, imagine when they take a break, this Word document that is also synchronizing the audio to the text. The lawyers, I'm sure, if they are indigent or working for indigent plaintiffs and defendants, wouldn't they rather want to be paying $1.50 per recorded minute and getting this and sharing the document with their experts and whoever else, as opposed to what they now have to pay? Continuing.
And thereafter, for the 19 years I practiced law, which I was reminded of last night when the judge who's still now 50 years a judge, who was my judge, I had a number of cases involving the Sioux City slaughterhouses, including Swift, Armour, Cudahy, and the newer facilities, including Iowa beef processors at that time. So I've been in a lot of slaughterhouses, seen a lot of people working in them, and consequently, you don't have to get into the gory details of how it works at its morale plant, I guess, which we call Kraft now, because I know what that's all about. However, it's a very interesting complication when the collective bargaining agreement and the rules of the FLSA.
I'm going to pause it again. The judge, of course, has a propensity for and other kinds of, and mind you, you'll hear from the other speakers as well, and yet the engine that we're using to create this real-time transcription, if it were being streamed to us live with superb audio, and this is what you're hearing right now, is not exactly superb audio. There's a bit of a tinny sound to it as it's coming to us. It's not of the grade that we would prefer, but that's a matter of just putting out a little bit more money for superior digital lapel microphones and wireless microphones, the ones that cost $500-600 each. That is a pittance to pay up front to be able to get a better transcript, at least from this particular courtroom in Iowa. Continuing.
Come into conflict. So I'll be interested to hear your oral arguments. I have reviewed the papers, and we'll start on behalf of Kraft.
Thank you, Your Honor. I think it's important to first note that the parties appear to agree that there is no Iowa law that is different than the Fair Labor Standards Act. So,
Do you concede that?
We do, Your Honor.
All right, thank you. So we're talking federal law.
only the Fair Labor Standards Act.
Now, you just saw a moment ago how the software, for some reason or another, decided to backpedal and erase something that was said and transcribed correctly, and then it continues on. From time to time, I don't know why, we're working on it, why that happens. However, when the lawyers access this transcript and then play back on any line of text in Yes Law, that missing portion or any other blooper or mistake will be overwritten, overruled. The mistakes and bloopers will become a non sequitur because the actual voice is linked, tied exactly to that word, phrase, sentence.
I think we can also agree that one of the courts to have dressed the Iowa law and federal law and donning and doffing and walking time issues out of Iowa is the Geenan case out of the northern.
Judge Bennett.
That's correct.
I'm familiar with it.
And that case was not appealed to the Eighth Circuit. I think it's also important to
I don't know that that strengthens or weakens it.
I'm not sure either.
I presume it was resolved by some kind of settlement after the decision by Judge Bennett, but continue.
Okay.
I'm not going to speculate about that.
Neither shall I. I think it's also important to start out that we note that the burden of proof in this case and the burden of proof in this motion is on the plaintiffs. There is typically an understanding that...
I guess that's not conceded, but go ahead. I'll hear your argument on that.
Sure. Under the Fair Labor Standards Act, there are exemptions and then there is the law. With respect to exemptions, they fall within Section 213 of the Act. Those exemptions require the employer to produce, by a preponderance of the evidence, information to show that the exemptions apply. With respect to the application of the law, the burden of persuasion always remains with the plaintiff to establish that they have not been properly compensated or that the work performed was work that is compensable under the Fair Labor Standards Act. There was quite a dispute amongst the, well, let me change that. Not quite a dispute, there was a minor dispute, let's say, between the federal circuit courts on this burden of proof and the burden of persuasion. And one court, one federal circuit court, simply, the Ninth Circuit, in the Alvarez case, which preceded the Supreme Court's review of that case, had suggested that Section 2030 is synonymous with an exemption and therefore must be narrowly construed and the burden of proof remain upon the defendant. Every other federal circuit court to address this issue has ruled or held that the Ninth Circuit was incorrect. The federal circuits out of the 7th, 4th, 10th, 5th, 11th have all said that the Section 2030 falls within the definitional sections of the Fair Labor Standards Act, and as such, it is not an exemption and is not to be read narrowly. Rather, what the court must do in deciding a case that involves a Section 2030 claim is actually look at the purpose of that section, and we'll suggest that the purpose is very well articulated.
And I'll pause it right there again. By the way, virtually 100%, only in certain pockets of the nation, is the United States bankruptcy courts using the live steno or voice writer, person who talks into a steno mask, who repeats what everybody else is saying, are used. Otherwise, 99% of all U.S. bankruptcy courts, it's all now digital. Some using video, but most using digital audio. So if you are a debtor or you are someone seeking money from a debtor, and some of those legal proceedings last for days, but it's mostly all legal argument. If you have a colleague of yours who is specializing in bankruptcy law, and they have to go to the court clerk and say, I need to have this transcript typed up as soon as possible. There is provided a list of qualified vendor contractors that the court does business with, and you had the ability of going to one of your choice, and the rates will be the typical rates that steno court reporters charge in the business, or keyboard typists, and even though they're not a steno reporter in the courtroom, but keyboard typists outside of the courtroom hearing the audio for the first time, they type character for character, and they charge as much as, because the federal rules of compensation for outside contractors who do the transcription is the same for everybody, or it should be. After all, a word is a word. This is expensive, and you don't get the final transcript until however you've ordered it for, rush delivery or regular turnaround. But with us, you could go to the court clerk and say, I want the audio, the digital audio, so that we can immediately, from our courtroom here, because we have Wi-Fi connectivity to the internet, upload the audio file to this service that's run by Steve Hubbard, and his service will give us same day or next morning or 24-hour turnaround of a rough draft like you're now seeing, where the words are synchronized to the text, and now I and my client and opposing counsel and their client, we can get together and perhaps agree on a settlement in this case. And all it's going to cost, as far as Mr. Hubbard is concerned, is just $2 per recorded minute for 12-hour turnaround. And we share that equally. So in other words, $1 per minute each. And that is a far cry from what you have to pay now as a litigator in the United States Bankruptcy Court. Continuing.
By the congressman who had proposed that section, Congressman Herter. Congressman Herter pointed out during discussion about the purpose of...
Spell the name of the congressman for the reporter.
Sure, it's Herter, if I'm not mistaken. That's correct, thanks. And
interestingly, Congressman Herter was correctly spelled by the technology. And that's the beauty of the online, the engine the universal dictionary to understand different voices. It also has a bazillion words that are matched to existing sounds, and that's why you have, in this case, Herter spelled properly, and there are many instances of that kind.
The purpose was created to give respect to the collective bargaining agreements that you started out by discussing at the commencement of this hearing. In fact, what Congressman Herter said is that in the bakery industry, the same industry to which you had referred earlier, for instance, which is 75% organized, there are collective bargaining agreements with various unions in different sections of the country which define exactly what is to constitute a working day and what is not to constitute a working day.
I'll pause it here. You just noticed about 4 or 5 lines being slapped onto the paper at once. What we're doing, as far as we're concerned, this is real-time transcription. What a steno writer does, of course, the words come up as soon as they strike a word or a phrase, it pops up. And that's the beauty of a stenotype or a voice writer who specializes in real-time technology, of their one voice talking to a program like Dragon Naturally Speaking that understands only their voice because it's been trained to understand that one person's voice. This technology we're using here, it goes way beyond. It understands multiple voices, and even voices that have an accent. And that's another detail we can get into later. But when there is a recess after maybe 90 minutes in the courtroom, imagine within 15 minutes of that break, the lawyers have got something to work with. And this one file, integrated multimedia file, is shared between and amongst all of the parties. So the more parties that are involved, one plaintiff suing 4 defendants, we're talking like about 25 cents per party, paying for, in essence, delayed real-time transcription with this kind of accuracy. And again, be mindful, this is not meant to be what a steno court reporter can do, but it's very close to it. And with the added advantage of having yes law, then synchronize each line of text with the audio, you have 100% confidence in the record that you know that you can play back. And chances are you'll be able to find, in 95% of the cases, finding that particular word or phrase in the document to be able to point and click on that line to play back on your smart device, be it a phone, tablet, or your PC. Continuing.
I would suggest to the court that that is exactly what is at issue here. What constitutes the working day for which the employees at Kraft's Oscar Mayer facility here in Davenport are to be compensated for? In order to get to that, again, coming back to our burden of proof, there are really 2 issues before this court. The first is whether the articles are in fact clothes within the meaning of section 2030. The articles are found.
Notice how counsel was leaving the microphone. He's searching for some documents that will be seen in the video. However, the microphone did pick him up for those 2 words. And this is a very good judge. He's very record conscious, and he asks the lawyers to make sure they're speaking into the microphone.
In docket number 86-2 at paragraph 14. Specifically, there are photographs found at that portion of the docket which illustrate exactly the articles of which we speak during this hearing. And as you will be able to tell, there is very little, or should be very little, debate whether.
Again, the transcript will have a margin of 5, 6, 7% bloopers and mistakes by omission and commission. This is only your working rough draft. You have to remember that. but it's a very cheap but very effective working rough draft. Knowing that we here at AMVSR have a team of what we call CAT, Computer Aided Transcription Scopists. They use the same software that the steno court reporters use. They get this text that they import as a rich text format file into their text editor, the same court reporting program that the stenotypists use to create a real-time record that is broadcast to lawyers in the courtroom, or when they prepare their own transcripts, when they edit and transcribe their own and proofread their own transcripts without the aid of a CAT digital text editor. We have the team to be able to take the same text and the audio file to morph what you now see into the final certified transcript. And you saw that earlier when yours truly was editing a file from an earlier demo.
Whether or not these are articles which constitute clothing under Section 2030. In fact, every case that has ever addressed, or that not ever, every case that has been addressed to this issue has routinely come back and said that these type of articles are clothing within Section 2030. The exception, noted by the plaintiffs in their briefing, are a couple of district court decisions, one of which was overturned, and another of which has now been superseded by an appellate court decision. So every federal appellate court to look at whether or not the articles in docket 86.2 paragraph 14 are in fact closed for purposes of 2030 have concluded that they are, with the possible exception of the Alvarez, again, the Ninth Circuit. Our brief explains why we...
Alvarez, A-L-B-A-R-E-Z, right?
Correct, yes, Your Honor.
For the reporter.
And so the burden of proof, going back to our burden as we started out, lies with the plaintiffs to show that these articles are not closed within Section 2030. It is not upon our hands to show that they are, in fact, but I think the case law is relatively clear and it establishes that fact. The second issue which this court is going to be called on to resolve is, when does the compensable working day begin? Exactly as stated by Congressman Herter. Again, because the compensable working day falls out by virtue of the Portal to Portal Act, as well as Section 2030 of the Fair Labor Standard Act. It is, again, not an exemption.
I pause it again so that, unfortunately, Congressman Herter didn't come across, and these things happen. But remember, there are court reporters out there today, stenotypists, who say that they are real-time writers. And because of circumstances, a freelance office will send over somebody who is on the border and they have to cover the job. Or there are just independent reporters out there who say, I'm a real-time writer. The lawyers say, fine, bring your stuff. And they get this kind of quality even from those people. Of the 100% of reporters there are today using the shorthand machine, maybe 20% of the total industry, and by the way, that industry is made up of typically people who are in their mid-50s and early 60s, and I'm in that category, that generation. We're all going to be retiring shortly. But right now, 20%, maybe 20% of the total industry is stenotypists who specialize and are certified as real-time steno court reporters. The rest, over that 20% into the 30%, 35%, that 15% margin, they say that they're real-time writers, but believe me, they won't be doing anything, or they could be doing what you're now seeing. They're making mistakes, and lawyers have no choice. Well, this is real-time. We can't get anything better, and we want real-time. Or we want a rough draft. So they work with something like this. Now, mind you, let's give credit to even that 15%. There is no Q&A in the transcript here. There is no speaker ID in here. But the product that we're delivering to you before we do the final corrections, if you want to go that far, you and your client and opposing counsel get together and say, well, we do need excerpts from the rough draft, or we need the whole deposition or day's trial hearing morphed into the final certified transcript. That's what the Court of Appeals wants. But if we can stipulate to most of this, our clients have listened to the audio, we've studied the audio and the transcript, and we're able to make a educated, learned decision that we do not need to pay extra for a final certified transcript. We've been able to narrow the issues, and on the appeal, if it's a trial, for instance, we can only need to argue certain pages of the transcript that we will have those certified, and therefore saving our clients a lot of money.
And the burden must lie upon plaintiffs to establish that the time for which they seek compensation is in fact part of the compensable working day. That burden does not fall upon Kraft.
I'm going to interrupt for a moment. Are we getting video? And how do we know that? In the case I've had over in Council Bluffs, I could actually see what was being taped. But Trevor, is that the case here? Is it actually being videotaped?
Yeah, Jake.
Here, the federal court judge is monitoring his monitor, showing the video. And this goes back again, as I advised before, 14 courts in the United States, federal courts, are experimenting with video technology in the courtroom. Typically the video is posted that same day or the next day so that anyone, let alone the litigants who need it the most, have access to a video record. With the technology and services we're presenting, they can now have both the video, audio, and multimedia transcript for a fraction of what they'd otherwise pay to the venerable steno or voice writer court reporter.
Jason Larson?
Yeah.
Jay Larson, I mean. Okay, thank you. So continue as a star of the video program.
I'll try not to.
We focus on the lawyers, not the judge.
Well, I think at the end of the day, we're going to have to focus on the judge, and I hope the judge can agree with our position here. When it comes to what is the compensable working day, I think we have to begin with both the purpose and intent behind Congress's passage of the Portal to Portal Act and Section 2030. In fact, nearly all of the appellate cases that are cited to this court in the briefing say the same thing. And just to show that I would speculate that plaintiff's counsel would agree with the purpose and intent behind the Portal to Portal Act and Section 2030, I'm going to take a quote directly out of the case that they rely most heavily upon, which is Franklin v. Kellogg. Specifically, Franklin v. Kellogg, the court says, although the FLSA was intended to protect employees, as discussed previously, Congress enacted the Portal to Portal Act in an effort to protect, quote, long-established customs, practices, and contracts between employers and employees. Much like the Portal to Portal Act, Congress enacted Section 203, open parent, O, close parent, to, quote, avoid another series of incidents which led to the Portal to Portal Act. And as more than one appellate court has described, the addition of Section 2030 was in fact to close a loophole, as Congressman Herter described it. That was the intent. So let's look at what each act actually, or what each enactment actually does. We can get that information directly from the Steiner case, which is a United States Supreme Court decision. That's Steiner versus the Secretary of Labor, Mitchell, Steiner versus Mitchell, and that's found at 350 U.S. 247. Under Steiner, the United States Supreme Court noted that the Portal Act was in fact established, enacted, to do away with what the Supreme Court had earlier done in Anderson v. Mount Clemens Pottery. If you might recall, and not recall because you were there at the time, but from reading of the cases, but Anderson v. Mount Clemens Pottery was an about face. The Congress had enacted the Fair Labor Standard Act, and for much time, employees were not paid for the period that they would spend walking on employer premises to get to the place where they were normally expected to perform their duties. A case, Anderson v. Mount Clemens Pottery, suggested that that was an incorrect analysis, and that in fact employees were entitled to compensation from the moment they came onto the employer's premises, so long as the purpose of that was some purpose to be performed for the employer.
I'll stop it once again here. If you notice at line 10, came onto the employer's premises. That's artificial intelligence, folks. That's throwing in the apostrophe S. In the old days of voice recognition, it would not be able to distinguish. And AI, artificial intelligence, is only going to exponentially get better. And from the research I have done, it's expected to really threefold, fivefold increase and do all kinds of things that we're not even imagining today as an end user. And unfortunately, this is technology that will eventually replace the human element for editing transcripts. It'll be online by voice recognition, going back and making corrections. If anybody's familiar with Apple Siri, you know that when you have a good connection to the cloud and you're dictating something in a text message or in an email, you'll notice the cursor going back maybe a sentence and a half and changing something if you're watching what's going on with your dictation. That's artificial intelligence. And when you think of the cloud doing that, and it's serving millions of people from around the world who are using their iPhones and tablets to do whatever they want, that cloud is humongous, and that universal cloud is outstanding.
And so all of this walking time became compensable. Congress said, wait a second, that's not what we intended with the Fair Labor Standard Act. And so 2 years later, they passed the Portal to Portal Act. And the Portal to Portal Act made it crystal clear.
Related facts on the podium as a courtesy to me, I don't have.
I didn't hear.
I asked Mr. Kaplan if he would mind leaving the stipulated facts on the
I see.
for me.
All right.
All right, at this point, what I did is I fast forwarded into the video that you can all access and play back the full 1 hour 37 minutes of the motion for summary judgment. I fast forwarded so that we could have Ms. Susskind start her argument before the federal judge, so that you can see another voice is coming into the fray here to be transcribed by AMVSR.
Thank you.
So for this motion, we have stipulated facts, and
Well,
you may proceed.
I'm going to put this on the floor to have it moved on.
Remind me again your name.
My name is Sarah Siskind. I, like Mr. Kaplan, I'm from Madison,
Thank
Wisconsin.
you.
My firm is Miner, Barnhill, and Gallen.
say hello to Barbara Kraft when you run into her. She's one of my favorite judges.
I will do that.
I don't think she's addressed this particular issue, at least not in a published decision.
She has actually, in the Spurley decision.
That's right. Oh, that was Judge Kraft. Right. Okay, thank you.
And in that decision, just
Good thing I mentioned that I know her. I reminded her that my favorite football player was Jug Gerard, and she said that was her favorite too. And that's way before your time.
I'm glad to say I don't know. I don't know who that is.
He was a quarterback tailback with the Wisconsin Badgers, 1940s. I shouldn't be that old, but I am. Now, you may proceed with the important issues of the day.
Thank you, Your Honor. Since we mentioned the Spurley decision, a case in which both Dan Kaplan and I were involved, I think it might be helpful just to inform Your Honor that the Judge Crabb initially ruled that 2030 did not cover similar items, garments that the Kraft employees were required to don and doff in that plant. She ultimately, the case was settled, but that issue carved out for litigation. Settlement contingent on the resolution of that issue, which was an issue of great importance to Kraft. She, in ruling, entering final judgment on the 2030 question, Judge Crabb indicated that changes in the law, since she had made the initial ruling that 2030 did not apply to the items in question, made her dubious, doubtful that the claim would survive. But she did not rule. The case, she didn't rule because it was not necessary for her to rule, because an independent claim under Wisconsin law provided the same full relief and made the 2030 issue unnecessary.
And we do not have that here in Iowa.
No, we do not.
Thank you.
And the case went up to the Seventh Circuit. That issue did. There was a controversy over whether it was before the court, since she had not ruled. The Seventh Circuit focused primarily on whether the federal law preempted the state law claims and found that it did not.
All right. Well, that's where I cut it off, and I think that everybody has seen enough of the transcript. So I'll just go back to the top here. And so this was done in real time. I paused it, of course, because we're controlling the audio. This was archived audio that's stored on the website of the Administration Office of the Courts in Washington, D.C. But as I have read many times, eventually I see the video becoming a major player. These 14 courtrooms that only do it now in civil courts, 14 courtrooms, the Judicial Conference, the body of jurists that make up from John Roberts, the Chief Justice of the United States at the Supreme Court in Washington, with other federal jurists at appeals level and at the trial level, Article III judges. These are the ones, these are the people that make the rules, and they expect that the possibility is there, and I'm sure that the criminal bar associations across the United States, the American Bar Association, would love to be able to see this expand into the criminal courts, because the criminal courts take up about maybe 90% of a judge's time in the federal court system. It's all criminal matters, and wouldn't it be nice to have federal trials, whether it's the mundane drug case or it's a classical like the Boston bombers and the mafia guys that are being brought into the courtroom, where they're going to throw away the key. The press, everybody would be logging on to that video stream to be able to watch and see from their smartphones the live trial. And hopefully AMVSR will be there to be one of the first vendors, service providers, providing a working rough draft transcript as the events are happening. Thank you.